Who's been long in the battle to preserve our Second Amendment rights on a number of fronts, the endless battle to preserve the gun shows, et cetera, et cetera. The man is tireless, and he's with us tonight, and you're fortunate to have him here. Please give a very warm welcome to Mr. Don Kilmer.
Yeah, except I'm a Lakers fan, not a Warriors fan.
No problem.
All right, I thought I'd start off with an update on various cases. Where's my sound effects guy? I'm supposed to be getting the funeral dirge from Mozart's symphony here. All right. Sylvester is the case that struck down the 10-day waiting period on a trial I did out in Fresno in 2014. The Ninth Circuit Court of Appeals, 3-judge panel, overturned that. There is a request for en banc review pending. I don't hold out much hope. I have a little section later in my talk where I discuss some of the statistics on the Ninth Circuit's batting average for Second Amendment rights. They're not as dismal as you might think they are, but they're pretty dismal. Tixeria is a case that I argued a week and a day ago. Tixeria is a case that had to do with zoning restrictions in Alameda County that basically prevented any new gun store from opening in Alameda County. They do this with what's called a distance restriction. We call it redlining. Basically what they say is first of all, they impose a bunch of requirements on you if you're a gun store, like extra security and extra build out for windows and doors, which probably sort of makes sense. They require heavy surveillance. They restrict the hours in which you can stay open. But the most onerous regulation that they use is that you have to be 500 feet away from everything. We challenged the 500-foot rule. The facts in Tixeria were that we applied for a variance, the clients applied for a variance. They needed to get the variance because they were 480 feet or 475 feet away from a residentially zoned area district that was over a 20-foot retaining wall, about the size of this wall here, of the 880 freeway, then across 8 lanes of the 880, and then you had to drop down another 20-foot retaining wall, and then there were some town halls over there, and they were within 475 feet of the tippiest, closest corner of my client's store. If you measured from the front door of the store to the disqualifying property, they were well within 500 feet. But they measured from the corner of my client's store, where there are no doors and no windows and no way to ingress or egress from the building, but yet that's where they measured from. Surprisingly enough, the Alameda Zoning Board approved the variance. They took a look at the client's business plan. They said there was a demand for having a gun store in that area, that they were going to do, they had experience. One of the guys who was wanting to own the gun store had 25 years of experience running a gun store in Contra Costa County. They had one of the retired sheriffs of Alameda County actually helping them put their application together. So the variance was actually approved. And then the housing association that was across the freeway and over the retaining wall and through the woods to grandmother's house we go, they filed an appeal which authorized the Board of Supervisors to just summarily revoke the variance. That was when we filed the lawsuit. We lost in the district court because the district court judge said, yeah, there's no right to buy and sell guns, therefore, this just has to be rational, and I suppose there's some rational reason for wanting to have gun stores located 500 feet from residential areas. The problem is of course, the people who hate our gun rights and who want to read the Heller decision as narrowly as possible say that you really only have a right to have a gun in your home for self-defense that shoots one bullet. And anyway, I'm getting a little bit hyperbole there. So the odd thing is that the one place where you're allowed to have a gun under Heller in your residence appears to be a sensitive area or a disqualifying characteristic of where you can have a gun. So it doesn't make any sense at all. Well, when we appealed the case, the three-judge panel who heard the matter reversed the trial court. It was a 2-to-1 decision. One of the judges on the panel basically agreed with the trial judge and said zoning restriction, nothing going on here beyond your way. But 2 of the judges wrote a very well-reasoned decision and says, look, this isn't a shoe store or a check cashing financial services business. These people sell fundamental, artifacts for exercising fundamental rights. They're more like an abortion clinic or a bookstore than they are like, for instance, a shoe store. And therefore, the government has to show, number one, does the 500-foot rule prevent any new gun stores from opening? And if that is a true statement, and the plaintiffs must be allowed to try and prove that at trial, we didn't have a trial. The case was dismissed without a trial. If we can prove that at trial, then the government must prove by clear and convincing evidence that there's no less restrictive means of achieving their government purpose. Nobody knows what the government purpose is for the 500-foot rule, but the government must justify the 500-foot rule. The county then hired one of the big 10 law firms in the country to come in and file what's called a request for en banc review, and this is where the entire Ninth Circuit takes a look at the case. I've done 5 en banc reviews in the Ninth Circuit in my legal career. Only one did I ever request. Every single one of them, of the other 4, I was dragged kicking and screaming to a 3-judge, or to defend a 3-judge panel to an 11-judge panel. Anyway, Tixeria was granted en banc review. I argued the case last Wednesday. If you want to see it, you go to the Ninth Circuit website and look at it, and if you really have some bleach to wash your eyes out with when you're done. We're probably gonna, I don't make predictions. The decision by the 3-judge panel was very vanilla and very conservative, not from the standpoint of politics, but from the standpoint of judicially conservative. All they said was the case has to go back to the trial court and you have to actually have a trial on the case. Well, that wasn't good enough for the Ninth Circuit. They reheard the case. An 11-judge panel is going to now decide whether the 3-judge panel was right or they want to agree with the trial court and not even let us prove our case. If that happens, Second Amendment Foundation and Cal Guns Foundation and Firearms Policy Council have already decided that this is one that they want to try and docket with the Supreme Court, and so Mr. Gura and I will probably petition the U.S. Supreme Court on that if that happens. If it doesn't happen, if we go back to the trial court, then y'all can come down and watch the trial if you want. Peruta and Richards. This was the companion cases dealing with concealed carry in California. The case was won. This is another case in the Ninth Circuit that was won and then lost at the en banc stage. Peruta is now docketed with the U.S. Supreme Court. I believe it was set for conference last week. That's where the judges decide whether they want to take the case or not. It was delayed, and I think the reason they're delaying it is they're hoping to get Judge Gorsuch confirmed and have his input on that case.
Another conference tomorrow.
Yeah, I imagine it will probably get postponed again, but we'll see. Pena was argued 2 weeks ago. Pena was the roster case. That was before a 3-judge panel. Alan Gurr was lead counsel on that, and I was assisting him. We'll see what the 3-judge panel does. That's another argument that you can go to the Ninth Circuit website and watch it on, I don't know if it's YouTube or whatever. It's a really good argument there. Another case that's active locally that I'm working on, it's being funded by Second Amendment Foundation, is Rodriguez versus City of San Jose. This is a case about returning firearms after a mental health hold. The government's odd theory as to why they don't want to give the guns back, even though the guns have been transferred to the wife. She owns the guns. She has a gun safe. She's had the combination of the lock on the gun safe changed. And they still don't want to give her her guns back because her husband is a prohibited person currently. The theory is, I guess, if you live with somebody who can't have a gun, you can't have a gun either. I'm aware that there are some civil rights organizations working on an assault weapon case and a magazine challenge. I don't know what the status on that is. I am not working on that case, or at least won't be for the foreseeable future. I have my own ideas on how that should be approached, and see me offline if you want to know the story on that. There's a signage case out of Sacramento that has to do with whether or not a gun store can advertise the fact that they sell handguns on the outside of their building, and whether or not that meets whether that violates the First Amendment or not. There are some other cases that are pending around the country that are very important to our rights, but they're not actually pending in the Ninth Circuit right now. There's a case called Binder Up that is now docketed with the U.S. Supreme Court. Alan Gurr is handling that. Binder Up is a case that has to do with when a state restores your rights after some disqualifying conviction, whether or not the federal government has to recognize that restoration of rights, and whether or not it's subject to an as-applied challenge or a facial challenge. Another case that is somewhat in limbo right now is Tyler out of the 6th Circuit that recently went en banc. This was a case that dealt with whether or not you could have your firearm rights restored after a mental health hold. Now, California is one of the few states that is actually does a pretty good job. I mean, there's still some flaws with California's statutory regime in this area, but at least California gives you the due process rights to try and get your firearm rights restored if you have had a mental health event. And where this comes up a lot now is some of our military personnel coming back from combat that are suffering from PTSD and what have you. California has a procedure where if you're placed on a mental health hold just for observation without a judicial finding, your firearm rights get suspended for 5 years, but you can ask a judge to restore your rights, and if you ask the judge to restore your rights, the burden then shifts to the government to prove that you have a mental health problem that should prevent you from having a gun. Unless you're, and this is not a clinical word here, unless you're nuts, normally the government loses in those hearings because the government has the burden of proving a negative. They have the burden of proving that you're not sane. Now, of course, if you go to court and you're wearing a tinfoil hat, and you get up in court and tell the judge that you want to be the Executioner General of the United States, you're not going to get your gun rights back, and that's probably a good thing.
Or wearing an NRA hat?
No, that doesn't hurt. That doesn't hurt at all. The law is somewhat different if there's actually a judicial finding to hold you over. If there's actually a judicial finding to hold you over for longer than a 72-hour hold, that kicks in a 10-year prohibition with the same right to go to court to have your firearm rights restored. That's the California law. But here's this twist. Federal law does not kick in on mental health holds until there is a judicial finding. So if there's a judicial finding, you lose your federal right to have a gun, but it's a lifetime prohibition with no right to go back to court and say, hey, I'm cured. The Tyler case out of the Sixth Circuit is a challenge to that federal policy. You'll be happy to know it was struck down. And so the government is before the election, the government was going to appeal the decision. We don't know what Attorney General Sessions is going to do. He may withdraw the appeal on this, in which case then the Sixth Circuit law will stand, but it's only the law in the Sixth Circuit. But it's actually the right decision, and we expect it'll go nationwide here too. Another case out of the Fifth Circuit is a case Mance versus, it'll be Sessions when it comes up, but it was Mance versus Holder earlier. That had to do with firearms commerce, has some facts that are very similar to the Tixeria case, and they kind of mirror each other, and we're hoping that that'll create the circuit split if we need one for the Tixeria case to go up.
Wasn't that like Enos?
What's that?
Wasn't that case like Enos v. Holder?
I'm not familiar with the second case.
Enos, E-N-O-S?
Oh, Enos. Enos is dead in the water. Enos is a domestic violence case. It's closer. Enos is closer to binder up because it has to do with rehabilitation after being convicted of a crime. We're going to take another run at the misdemeanor crime and domestic violence. The timing is just not right on it yet.
Sorry to interrupt.
It's good, no worries. Okay, I'd like to talk to you a little bit about the state of the court and what's going on with the Gorsuch nomination. A little more than a year ago, we both mourned the death and celebrated the life of Antonin Scalia at a meeting here. Of course, Judge Scalia wrote the Heller opinion, joined in the McDonald decision that incorporated that right, this right to keep and bear arms to the other states. Judge Scalia was kind of a giant when it comes to Supreme Court justices, not just because he was a funny man and a jovial character and a real personality, but because he advanced the only, or at least the first coherent theory of constitutional interpretation, which is now the dominant theory that even the liberals acknowledge. Now the liberals try and twist it and change it and subvert it and pollute it, but it is a theory of constitutional interpretation that is called original public meaning. Do not confuse original public meaning with originalism. This is a liberal trick to try and get you to go down the garden path, or what I call down the rabbit hole, or through the looking glass. Originalism is not, well, what would James Madison have done, and what would George Washington have done under these circumstances? If we could resurrect them and show them the internet, what would they have thought we should do? That's not originalism. Or that's not original public meaning, okay? Never ever lose track of or lose sight of the fact that we are interpreting a law. The Constitution is not a poem, okay? It's not an aspirational prayer. It's not something that we, that we set down in our journal about how we wish the world ran. It's the law. It's the law that we use to govern the government. The Constitution doesn't even apply to us. And it protects us. It protects our liberty. It protects our property. It protects our right to our lives. It forces the government to go through due process if it tries to deprive us of life, liberty, or property. But the Constitution, never lose sight of this fact, applies to the government. It limits the government. That's why original public meaning needs to be understood in these terms. Original public meaning is You start with the text of the Constitution. Do not pass go, do not collect $200. Your interpretation is done. If it applies, you're done. If there's an ambiguity, and the burden is on the person who says there's an ambiguity to prove there's an ambiguity, can you go past the text? Original public meaning says, once that showing has been made that there is an ambiguity on what the Constitution says on these particular set of facts, then you go to the original public meaning. Original public meaning is not getting out your crystal ball and trying to figure out what James Madison would have done. It's getting out the books, the letters, the Federalist Papers, the Anti-Federalist Papers, the writings of Thomas Jefferson, the writings of James Madison, and not their private letters between themselves, their public statements, original public meaning. Their original public statements about what that particular provision of the Constitution says. That's original public meaning. Now, why is that important? Because this document, the Constitution, belongs to us. It is our rules for how the government gets governed. So that means that the people who wrote the amendments and wrote the Constitution, and then the people who ratified the Constitution and ratified those amendments, what did they think when they were drafting that? The Constitution, in an unfortunate phrase that I hate, and I think Justice Scalia hated too, and he used to make fun of people for it, is not a living document. It's not a living document any more than your mortgage agreement is a living document. How would you like it if 10 years into your 30-year mortgage, the bank just came up and said, you know, the economy's kind of gone to crap and interest rates have gone up and we're going to change your 3.85 interest rate to 16% because we really need the money. That's what a living document is. No. When you set something down in writing, and you set the terms down in writing, that document is dead, because it is to be interpreted on the day it was written. That's what we have documents for. That's what we have contracts and charters and statutes for. If the meaning of the words changes with the wind, that's what kings do. That's what tyrants do. That's true tyranny. Neil Gorsuch comes to us out of the 10th Circuit that covers the states of Colorado, Wyoming, Utah, New Mexico, Oklahoma, and Kansas. He was appointed from the list that Donald Trump said he would use. For the first time in this country's history, a president said during the campaign, the Supreme Court is so important, I will use a list, and I promise to use that list for my pick. Now, Donald Trump hasn't promised to use that list for every pick. He only promised to use that list for the first pick. Well, let's knock on wood and cross our fingers and hope he keeps that list in his breast pocket if another appointment opens up with the Supreme Court. But Donald Trump kept his promise, and in my humble opinion, if the only thing that happens during his presidency is that he gets Mr. Gorsuch seated on the Supreme Court, he will have exceeded my expectations. It looks like Mr. Gorsuch will probably get confirmed either by meeting the Senate threshold to bypass the filibuster, or perhaps the Senate will invoke the so-called nuclear option and destroy the filibuster, at least for Supreme Court appointments. This appointment is worth getting rid of the filibuster, which is a retarded rule anyway. I mean, there are places in our Constitution where Congress and even the Senate are required to enact something with a supermajority. Treaties, I believe, are one of them, and of course, to amend the Constitution requires a supermajority. So supermajorities are a good idea, but the Senate just basically made up out of whole cloth the filibuster rule when they first started a number of years ago. It's nice in sentiment, but it's starting to be, it falls into that category of some of these rules are good as long as it's not a suicide pact. Make no mistake, Judge Gorsuch getting appointed to the U.S. Supreme Court is what will keep the Second Amendment alive for the next generation. It's that important. All right, as far as the state of the court in general, the state of the federal courts, and I'm only speaking about federal courts because our state courts are an absolute abomination when it comes to the Second Amendment. So I'm not even going to talk about them. The circuit courts are, unfortunately, with the possible exception of the Fifth Circuit, the 10th Circuit, the 6th Circuit, and one other, I'm thinking the Third Circuit, are openly hostile to the Second Amendment. In 2014, there was the very, very rare occurrence of a dissent filed in a denial of a petition for certiorari. And if you're a thinking person, you just said, oh, why is he throwing Latin at us? Okay, that's nonsense. Okay. Well, the U.S. Supreme Court has very, very limited mandatory appellate jurisdiction. There are very few cases that the U.S. Supreme Court has to take. The bulk of its cases, the majority of all the U.S. Supreme Court cases, are heard on what's called a writ of certiorari. Again, there's Latin. It just basically means a writ of review. It's where the Supreme Court or the higher court looks at all these petitions, people who say, you know, we want you to hear our case. They pick the ones they think are important based upon trends in the law or some very, very important right, and they agree to hear that. Anywhere in the neighborhood of 5,000 to 10,000 petitions for certiorari are filed every year with the U.S. Supreme Court, and the Supreme Court takes literally a handful of those, maybe 100. 100 would be a good year. All right? In the Jackson dissent, Jackson was a case out of the Ninth Circuit where there was a challenge to San Francisco's ordinance that banned hollow point ammunition. Despite the fact, by the way, that hollow point ammunition is the required ammunition for federal law enforcement throughout the country. That's their regulation ammunition, okay? It's also the preferred ammunition for most police departments. And that's because hollow point ammunition is good stopping power. But, you know, hollow point ammunition has this real sexy sound like cop killer bullets and assault weapon and all these other nonsense terms. So Jackson was a challenge to San Francisco's ordinances that I think required you to lock your handgun up in like a gun safe or something at all times, unless you actually had it on your person, which leads to the perverse result of, if you want your handgun available for self-defense in your home, and you don't want to keep it in a safe, you have to keep it on your person. And so if the police come to your door and say, was there a disturbance, you're walking to your front door with your gun on your hip. And that just sounds like a nightmare to me. But anyway, the ordinance was challenged. The case was dismissed. The Ninth Circuit affirmed on appeal. There was a certiorari petition filed, a petition for review. It was denied by the Supreme Court. And then in a very, somewhat unusual, they don't happen very often, Judge Thomas and Judge Scalia joined in a short 4-page opinion basically saying the Ninth Circuit is not honoring the spirit and the letter of the law in Heller. They're doing the Second Amendment analysis wrong, and we think this case should have been granted review. Then not 4 or 5 months later, an assault weapon case out of Illinois called Friedman got the exact same result. There was a law that was upheld in Illinois saying that if a gun looks scary, you can ban it. And the Seventh Circuit upheld that law. A petition went to the U.S. Supreme Court. It was denied review, and then Judge Thomas and Judge Alito wrote a dissent from the petition for certiorari saying the Seventh Circuit is not doing the Second Amendment right, and we should have taken this case for review. The Ninth Circuit, as I alluded to earlier, has a dismal record on the Second Amendment. As an officer of the court, I'm somewhat constrained in my criticism of the court because I'm not permitted, well, actually, if I want to keep my law license, I'm not permitted to publicly criticize the decisions. I can publicly criticize the decisions of the court. I can't impugn the motives of the court. So that's why I'm going to let you do that. However, I can tell you what the statistics are, and I can tell you what my disagreements are. The Ninth Circuit has not endorsed a single, with one exception, a single pro-Second Amendment case in 25 years. Every single Second Amendment case that has gotten to the Ninth Circuit has either, if we won in the trial court, it's reversed by the appellate panel, or if we lost in the trial court and won with the original appellate panel, it gets en banc. And the sole exception, you're going to love this one, is a case called United States versus Gomez. And this was a case of Mr. Gomez was being tried for being a felon in possession of a gun. Now, the reason he had a gun was because he was a snitch. I think I'm remembering the facts of this case right. And the people who he snitched out wanted to kill him. So he figured out this way to keep a gun handy without having it available all the time in case somebody wanted to kill him. And of course, he was found to be in possession of a gun and having been convicted of a felony. The government wanted to put him in jail for being a felon in possession, where of course he probably would have been killed in prison for being a snitch. He wanted to argue to the jury that even a felon has the right to possess a gun for the momentary or the transitory purpose of immediate self-defense. Interestingly enough, this is almost the burden of proof that the Ninth Circuit puts on law-abiding citizens for having a concealed carry in public, is that you must be under immediate danger of death or great bodily injury in order to have the defense of carrying a gun in public. But of course, the court didn't agree with that either, and therefore Peruta is going up to the U.S. Supreme Court. Anyway, Mr. Gomez prevailed on a Second Amendment theory that yes, even a felon has a right to self-defense as long as he doesn't possess the gun at all times, and he only picked it up for the moment he needed to defend his life, and he put it right back down and called the police and was a good boy. That's the single case in the last 25 years where a Second Amendment argument has gotten a favorable result from the Ninth Circuit. And again, it's not just the Ninth Circuit. It's the Fourth Circuit, the Seventh Circuit, and the Second Circuit are all openly defiant of the decision in Heller and McDonald. And these judges have lifetime appointments. So judicial appointments from this point out, ladies and gentlemen, are critically important to your Second Amendment rights. Now, there's not much we can do with the two dipshit senators we have in California, okay? Because, I mean, they thoroughly embarrassed themselves during the Gorsuch hearings. There might be some excuse for Dianne Feinstein because she's not trained in the law, but Kamala Harris was our Attorney General. She was the chief law enforcement officer of this state. And she's a moron. She does not understand the first thing about the Constitution, except to use the word to talk about things that she likes. All right. If you're going to take notes, now would be the time to get out your pen and paper, because I have some reading recommendations for you. The best book I have read recently on interpreting the Constitution And he does an excellent, it's a very short book, by the way, very well written. Randy Barnett, a professor at Georgetown Law School and an acquaintance of mine, last summer came out with a book called Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. It's available all the usual places, Amazon, Kindle, and what have you. Mr. Barnett, or Professor Barnett, explains original public meaning in, it's almost an insult to say he does it in layman's terms. He actually does it in legal terms, but he's so clear and precise in his explanation that it does not read like a brief. It reads like just what it is, excellent prose. It's called Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Randy Barnett, B-A-R-N-E-T-T. For those of you who do the legal groupie thing, Randy Barnett argued Raich versus Gonzalez, which was the medical marijuana case that he took all the way to the U.S. Supreme Court and unfortunately lost after having won in the Ninth Circuit. He also argued the Affordable Care Act case where he won on the law 5-4 before the Supreme Court, but then Roberts flipped at the last minute and said, well, the tax or the fine is really a tax, and it's just a whole mess. The book explains both the Raich case and the Affordable Care Act case. But what I wanted to give you a preview on is what he talks about in the book is that there are two fundamentally different ways of understanding and interpreting our Constitution. And I want to preface this with making sure you understand these categories have nothing to do with Republican and Democrat like the parties, okay? So I'm using Republican and Democrat with a small r and a small d. The Democrat approach is embodied in the idea that rights come from government, or they come from culture, or they come from society, or the nation, or the race, that it's some kind of collective entity that figures into how we implement public policy. And under this regime, it's only necessary to decipher what policy the majority wants and then find some just and law and order way of implementing this rational policy that the group or the collective wants. And that the Constitution is a way of making sure that that happens. So it's this idea that our rights are collective and that therefore, but that the collective or the group has to somehow, respect the rights of the minority. I guess make sure they have comfortable bunks at the internment camp or something, I don't know. The Republican approach is, and this is the one, and he makes no bones about the fact that this is the position that he thinks is correct, and I happen to agree with him. The Republican approach to our Constitution is that government represents us, so i.e. republic represents, rather than governs us, and starts with the premise that the individual is the irreducible component of society. Now let that sink in. It's not your race, it's not your gender group, it's not your color, it's not your age, it's not your ability or disability, it is the individual. And as our Declaration of Independence says, governments are instituted among men to secure life, liberty, and the pursuit of happiness, which gets translated in the Constitution to life, liberty, and property. But the point being is that rights are antecedent to and pre-existing government, and that it's the government's job to protect those rights. It's not to protect the integrity of the race. It's not to ensure the will of the majority. All of that stuff is nonsense. The clearest expression of this, and perfectly set up as an exercise for the student, is the Heller decision. Folks, the rights that you meet here to celebrate every month is not just your right to keep and bear arms, and not just your right to self-defense, and not just your right to hunt, and and not even just your right to rise up against tyranny. What the Heller decision did, and this is why we still celebrate the life of Antonin Scalia, is the Heller decision set down once and for all this idea that original public meaning is the way to interpret the Constitution. Based on the idea, and you can read this almost verbatim in the Heller decision, that your rights are pre-existing. The Bill of Rights only sets them down and says this is government's job to protect these. It does not create your right. The Heller decision set up the battle lines perfectly. On the one hand, the plaintiffs, the ones who were challenging the law in the District of Columbia, said, we don't have to be a member of a militia. We don't have to be a member of a group or a collective to exercise our right to keep and bear arms. The government's case was, yes, you do. You have to be a member of a militia, and you have to be a member of a well-regulated militia. And of course, we know what rabbit hole that goes down. The other, I'm going to add some more to your reading list here, so take a look at Randy Barnett's book, go back and read the Heller decision. If you really want to punish yourself, read the McDonald decision too. Or, if you want to be inspired, read the concurring opinion in McDonald written by Judge Thomas. Also, go ahead and take a look at Federalist 10. Now, I can recommend all of the Federalist papers, but if you're going to only read one, read Federalist 10. This is James Madison's masterpiece on why democracy leads to tyranny. You know, folks, we sometimes throw terms around and we don't really understand what they mean, but the United States is not a democracy. It's a republic. I think one of my favorite movies, because it has a lot of gun porn in it, is Mel Gibson's The Patriot. But he has this one line in there that I've always loved, and that is, why should I trade one tyrant 3,000 miles away for 3,000 tyrants 1 mile away? And that pretty much captures the work order, or the tasks that our founders set out for themselves when they wrote the Constitution. They took a look at the Articles of Confederation that they had after they kicked the British out of the country, and they said it wasn't working. And one of the reasons it wasn't working was too much democracy. There are, what, maybe a dozen or 20 or 30 banks in this country, you know, commercial banks that do housing mortgages. And there are literally hundreds of millions of people, maybe 80 or 90 million have mortgages on their house. Can you imagine if we were a pure democracy, what would happen to the banking industry if it was just 20 or 30 banks versus 80 million people who say, I really don't want to pay off my mortgage? Well, that's what was happening under the Articles of Confederation. The debtors were basically telling the creditors to go screw themselves, they weren't going to pay. And that was causing problems. That was causing problems with commerce. That was one of the primary reasons why the Constitutional Convention was called again in Philadelphia, because the government wasn't able to ensure contracts. So Federalist 10 it's almost, if you live and breathe this stuff like I do, it's poetry. And I don't mean that in a quaint or cheap way. But James Madison was one of the foremost political philosophers of the human race. And he doesn't get enough credit for that. Of course, he was also a founding father and a president of the United States, so maybe some of that stuff gets lost in the static. But this man wrote about how do you balance the need for popular sovereignty against the fact that sometimes the population doesn't know what the hell it wants, and sometimes they make bad decisions. Exhibit A on that here in California was that our fellow citizens, our fellow Californians, voted last November to restrict our rights because they don't like us, they don't like what we do, they don't like the other ideas we stand for. There is no crime wave. There is no proof that high-capacity magazines, or what we call standard capacity magazines, are causing bloodbaths. We all know that assault weapon is a made-up term, but we're not politically popular. We're in the minority. And so the majority said, well, tough luck, you just don't win. But that's why we have a Bill of Rights. There are certain things that are off limits to majority rule. Quite frankly, I think that the Bill of Rights was too long, and many of you old-timers have heard me speak here before, so you're gonna know the joke that I'm gonna say next, and that is, the Bill of Rights is too long because it should have stopped after Congress shall pass no law. Which is the beginning words of the First Amendment. Anyway, read Federalist 10. Living Constitution is not a constitution at all. Originalism without understanding original public meaning is a rabbit hole that you just can't go down. Don't get stuck with being called an originalist or being tried to defend the position of originalism. Talk about original public meaning. Get yourself educated on what the Federalist Papers actually say. Be able to tell people who you get in discussions with, and be civil, be polite. Don't call them stupid until you actually see the Bernie sticker on their car. What Scalia and Gorsuch advocated is that it's not the job of the court to try and figure out what Madison and the other founders would think about the internet. There's no way to know that. It's our job to try and understand what they wrote about when they were talking about rights and liberties. These are the decisions that we have to live under. And never forget that the Constitution is a law that does not bind the citizens. It is a law that binds the government. Thank you. And now for the call-in section of our show. I'll take questions of any nature on any topic, except do not start a discussion with, I have this fully automatic, an AR-15 at home. I don't know what to do with it, that I inherited from my uncle. Wink, wink, nod, nod. Don't start any discussion with that, okay? If you have a hypothetical like that, see me in private. But otherwise, if you want to ask generic questions, I'll either give you the right answer or I'll bullshit you into thinking I gave you the right answer. All right, I'm going to go left to right and then right to left, and then I'll look to where's Supreme Leader to tell me that I'm done for the evening. So starting over here, yes sir.
So in theory, regarding Jackson versus San Francisco, which was the case involving the San Francisco you have to lock your gun or put it in a trigger lock unless if you're wearing it in the shower.
Right.
Since the Supreme Court decided not to take the case on plenary or whatever we do, if after Gorsuch is confirmed to the Supreme Court, can it be possible in theory that a criminal challenge where a person violates section San Francisco Police Code 4512 gets put through the criminal justice ringer in San Francisco and gets convicted, is it possible that the Calvin's Foundation, Second Amendment Foundation, or even CRPA funds his direct review appeal all the way to the Supreme Court? And would it be possible for the Supreme Court to take that case on direct review and on the basis that, look, guys, this rule again is unconstitutional and it needs to be struck so that our client can be set free? Thank you.
Okay, let me see if I can unpack that one. A denial of a petition for certiorari, whether there's a dissent or not, has no legal significance whatsoever. It doesn't mean that the Supreme Court agrees with the Circuit Court. It doesn't mean that the Supreme Court disagrees with the Circuit Court. It means zilch, zero. What it does mean is if the case is not accepted for review, is that the decision of the Circuit Court is the law in that circuit. So it means that whatever the Ninth Circuit conclusions came to in the Jackson case will be the law for the entire Ninth Circuit, which is California, Oregon, Washington, Nevada, Idaho, Washington and Oregon, and Alaska, and the Marianas, and Arizona, and I think Alcatraz too, but I'm not sure. Anyway, side note, one of the things that's being discussed in Congress now is splitting up the Ninth Circuit. You should be for that, by the way. I mean, there are good arguments on both sides, but it's too unwieldy a court, it's too big, and there's no reason why people in Idaho should have to put up with the stupidity of California. Back to your question, though. Yeah, it is possible to raise a challenge to the San Francisco ordinance again, but one of the things you need to understand is that these ordinances are passed at the city and county level. They're not passed to actually do anything. They're passed to do what we call in litigation, constitutional litigation, to have a chilling effect, okay? Because the worst thing that could happen to try and challenge this law is some guy who's beating his girlfriend and torturing his children and dealing drugs and selling child porn off of his his internet server gets busted for having a gun that's not in a locker. So he's got this little teeny misdemeanor sitting there, and he's going to go to prison for 20 years for all his other crap. And it's just not the kind of case you want to take. And by the way, no DA in his right mind is even going to charge it. Okay? These laws are not designed to actually stop criminals. They're designed to scare law-abiding people into exercising their rights. Because, we're the ones with something to lose. Who wants to pay a lawyer like me, $60,000, $70,000, $80,000 for a criminal trial to stay out of prison? I mean, your choice, okay, I'll buy the it's $20 for a stupid safe, I'll buy the safe, I'll keep my gun in my safe. Or what the government really wants is, it's too much trouble to have a gun. There are too many risks, there are too many rules, I can't read everything. I'm sure I'm gonna violate some stupid rule and not know it and get in trouble, so I'm gonna buy a dog whistle or something, I don't know. Okay, but yes, in theory, there's no law preventing a second challenge, no law even preventing a second civil challenge once the complexion of the court changes. The only thing we have to do in federal court, and I got caught doing this, and is you just put a little footnote in your complaint that says, I'm aware that the law in the circuit is adverse to me, and I'm pleading this in good faith because I want to take your ass to the Supreme Court. You don't say it that way, but that's the gist of it. But you're correct. You're intuitively correct that you can't bring a case that is contrary to circuit law, but you also have to preserve an issue for a higher court if you need to. So you plead that knowing that you're going to lose, and then you just try and get through the court system as fast as possible. All right, next question. Yes, sir.
Can anyone, is it feasible to bring a suit against any entity, state, county, city, for these stupid rules, which they all are, as an infringement? Because the last words of the amendment say, which shall not be infringed. And 90% of them are infringements.
Yeah.
Why can't that be a case?
Well, that is basically the cases that we do. But the problem is you have to break it down one at a time. one of the provisions of our Constitution that actually governs our federal courts, and it's actually a very important rule, is that federal courts may only take actual cases or controversies. So in other words, federal courts are courts of limited jurisdiction, or at least they're supposed to be. Okay, so that's why your run-of-the-mill murder case and burglary and armed robbery and domestic violence don't get tried in federal court. Now they do if it happens on federal land or within a federal jurisdiction or something like that. But the bulk of the litigation in this country happens in state court, and it happens in state court for a reason, and that's because we're supposed to look to our states for, you know, the public policy that's closest to home. Now, the Second Amendment, of course, is a constitutional right. It's national, and you should be able to go into federal court and say, well, these laws are stupid, but it just doesn't work that way. You have to have an actual case or controversy. You have to have a provable harm. You have to have a plaintiff who's been damaged. You have to be able to plead your case. And courts, federal courts are not allowed to give what are called advisory opinions. So that's probably not a satisfactory answer, but that's the best I got. Yes, sir.
Recently, about a day or two ago, there was a case in Oklahoma where 3 home invaders were shot by a 23-year-old man with an AR-15, and the 2 networks said that the authorities are trying to determine if this is a stand your ground case. But wouldn't that be more like a castle doctrine case, because the home invaders were shot inside the guy's house?
In order of stupidity when it comes to gun policy, top of the list are journalists, and right under that is politicians, and right under that are police. So you're probably absolutely correct. If this was a shooting in the home, and it meets all the elements of self-defense, it is a castle doctrine issue, not a stand your ground issue. Stand your ground issue can be in the home, but it's typically a shooting in public where you're not under a duty to retreat. Yes, sir.
Yeah, are you talking about filibuster rule? I was reading an article, I think, on National Review about how that came about and why it's from that. It was originally that you filibuster, but it had to be, he was filibuster, you couldn't do any other Senate business, all of this filibuster was ongoing. And so basically they could go over on for a few weeks, and then they ran out of time, and then that was it. They could continue on to resolve the issue. Now they can go on to do other things.
Yeah.
And so basically the filibuster can be indefinite. So do you think that's something that maybe something that we can push forward in the Senate, is to get them to put their original filibuster rule back?
Yeah, well, unfortunately, the Senate gets to make up its own rules. So we don't have any input into that. We just get to decide who's a senator and who's not. But once they're there, they get to make up their own rules. The filibuster rule was designed, in theory, to protect the rights of the minority being a single senator of the 100. It's 100 now, but it wasn't always 100. We didn't always have 50 states. But it was designed to allow a minority of one to literally, you know, what was William F. Buckley used to say, stand athwart history and yell halt. And so it was pretty powerful. I mean, there's a good dramatization of it all. There's a lot of other things that are kind of hokey about the movie, but Mr. Smith Goes to Washington is a pretty good, the mechanism for filibuster and how it's supposed to work is Hollywood kind of got that part of the movie right. Yeah, you're right. The filibuster rule now is it's just, hey, you know, I'm filibustering, but not really. So put me down for a filibuster, and I'm going to go get a sandwich or something. Yeah, I suppose that one way to reform it would be to say, to filibuster, you actually have to filibuster. You have to be standing there talking. You can yield the floor to somebody who can either cut your throat and then turn the gavel back to the speaker, or can continue the filibuster for you, and then you can swap it back and forth, and theoretically you can get a cabal of 5 or 6 senators that can keep this going for months at a time. Yeah, I don't have an opinion one way or the other on it. It's necessary to destroy the filibuster rule to seat Judge Gorsuch. That's a good trade in my book. Yes, sir.
Relating to the circuit courts and these lifetime appointments, I know the state Supreme Court and one of the state courts have term limits. They have to be reaffirmed every 10 years or something. What would be involved in getting these circuit courts limited?
Well, there's 2 answers to that. One is you'd have to amend the Constitution. Although, actually, you might not have to. I would need to look at my copy of the Constitution to answer your question. The lifetime appointments are for the Supreme Court. There's only one court mentioned in the Constitution, that's the Supreme Court. Every other federal court, from the circuit courts, down to the district court, down to the bankruptcy court, down to the court of claims, every other federal court is a creature of statute. So then the question becomes, could Congress by statute say, everybody but a Supreme Court justice is subject to a 12-year term and out? Interesting question, I don't know. If an amendment to the Constitution is necessary, I'd be for one. I don't think lifetime appointments are a good idea for anybody. Now,
historically,
hang on one second.
under Jefferson, didn't that happen? Didn't the Congress reorganize the courts and some of the judges lost their judgeships?
That may or may not have happened. You may be correct on that. The interesting thing is that it is possible to impeach Supreme Court justices. It's been done. It wasn't done well in the past, but it is possible to remove a judge just because you don't like them. Okay? Impeachment is a political act. It is not, does not have to be for cause. It can be literally, we disagree with you and you're off the court. You know, they've got to be able to have the numbers to make the impeachment work. But it's an extraordinary remedy and not one that would probably go over well. Yes, sir.
I think the clause in there is they shall hold their offices during times of good behavior.
Yeah.
And what defines good behavior? That would be.
You're absolutely correct that that's what the language is. What that has been interpreted to mean is that they are subject to impeachment. I believe there was one Supreme Court justice. I mean, there have been judges who've been removed for cause. There was a district court judge down south, I can't remember, Alabama or Mississippi, who, you're gonna love this, who got caught doing something underhanded. I can't remember what it was. So he was impeached and removed as a judge and then ran for Congress, and now he's in Congress. Yeah, that's it. Yes, ma'am.
So for those times when the justices don't know how to interpret words like infringe or militia or well-regulated, do we have available Noah Webster's dictionary from the time? And if so, why do we ever need to have those cases where over those words?
Well, because judges and lawyers need jobs too. I mean, they've got expensive law degrees to pay off. They went to Harvard, for crying out loud, all right? I don't have a good answer for you. I'm as frustrated as you are when I read the Second Amendment and I see shall not be infringed. And I know what it means. The problem comes down to what I was talking about earlier in my little talk to you, and that is, if you have this fundamental schism in your country of rights are antecedent, government exists to protect rights, you start with the rights of the individual and move from there. And at the other side you have, no, society is antecedent to the individual, and any rights or privileges that they have are the gift of government or the gift of the majority. You're gonna get a different result, okay? And we're living in a time and age where we're getting that result. I mean, the progressives, right around the time of Woodrow Wilson, were very, very effective at actually amending the Constitution. Okay, it was the progressive era that gave us the income tax, gave us popularly elected senators, gave us women having the vote, which I think was a good thing. Okay? Just because the income tax was a bad thing doesn't mean that women voting is just because the income tax was a bad thing doesn't mean women voting was a... I keep getting that backwards. Just because the income tax is bad doesn't mean that women voting is bad. Well, there's a lot of Freudian slips in there.
Unless they're voting for Hillary.
It also gave us prohibition, remember? I mean, the progressives came in to office in the early 1900s with 4 constitutional amendments. They gave us popularly elected senators, women's suffrage, the income tax, and prohibition. We used the Constitution to repeal prohibition. But since then, we just say, hey, Article 5, you don't need to amend the Constitution anymore. You don't need to amend the Constitution if you can get 5 justices on the Supreme Court to change the meaning of a word. It's just economics. It's cheaper to do it that way. Just make sure that the right judges get appointed, and you're home free. You don't have to amend the Constitution anymore.
But that's the catch.
Yes, sir. Or it's called amendment by vocabulary drift, I think was one of the funniest ways I heard that. Yes, sir. Or linguistic drift.
Okay, so we have these bad circuit courts filled with bad judges.
Well, not all the judges on the circuit courts are bad. We've got some good judges in the Ninth Circuit that know what they're doing.
Okay.
And every now and then we hit the lottery and get a good decision, but...
Okay, so we have these bad attitudes in the circuits and lots of bad judges and lots of bad lawyers and everything. So the supply is coming out of the law schools, I assume. The liberals seem to be running the law schools. I assume that's where the supply has to be attacked and changed.
All the
is
schools.
anyone working on, I mean, how do we change the legal profession so this supply of messed up brains isn't making law for us?
I have to plead that I'm a limited being and not able to effect omniscient change or omnipotent change on the rest of the world on that one, my friend. I don't have an answer for you. That you're asking me how to change the culture, the cultural drift of this country for the last 60 or 70 years, when we decided, sometime just shortly before I was born, that the government existed to give us free things. So until we fix that, short of saying nobody from Harvard can sit on the Supreme Court, I don't know what you do about that. Thank you.
Sounds like a plan, though.
On this,
Yes.
I just would love to get your thoughts on the whole concept of Cal exit.
Of what?
Cal exit. Cal exit. Or very active.
Well, I guess being selfish by nature, I want to know what it's going to do to my housing value. But I just don't see it happening. I mean, there's an argument to be made of, yeah, good riddance, okay? But maybe the line should be along the San Andreas Fault or something, I don't know. But, we fought a civil war over this issue, that we're a united country, and we live under one constitution, and some things we like about it, and some things we don't. One of the arguments I made in the Tixeria case And you can be the judge whether I did a good enough job on it or not if you want to watch the tape. But the point was this, look, there are unpopular rights. The right to an abortion is unpopular in Alabama and Texas and Mississippi. And those states do everything they can to restrict the right of abortion. And they do it with building codes, and they do it with restrictions on doctors, and they do it with, waiting periods, believe it or not, okay? Well, gun rights are unpopular in the Bay Area. They're unpopular in California. It's starting to be unpopular in Oregon and Washington, too. But we live under one Constitution, and the courts exist, the federal courts especially exist, to protect unpopular rights. That's what the whole Civil War was about. Slavery existed in the South and was almost dead, a dead institution in the North. But the rights of free men are supposed to exist for everybody throughout the entire country. The South said no, North said yes, and then they broke out their rods and hunting pieces and had at it to the tune of 600,000 lives. I just wouldn't like to see that happen again. I think it'd be a bad thing. I'm gonna take you to next and go to the back first because they have their hands up first. Yes.
You want to back?
Mr. Schrader, I think, was next.
You mentioned the possibility of them subdividing the Ninth Circuit. So let me ask a question on that. So the president selects judges for the Supreme Court. Does he also select judges to fill the federal seats like tonight?
The executive branch nominates all judicial offices, which are then confirmed by the Senate. On down to the district court, circuit court, and Supreme Court level. I think bankruptcy judges and magistrates and court of claims are administratively chosen, but that's...
So if the president who likes gun rights were to gerrymander the existing seats and fill others, is it possible he could straighten the problem out of California and let the other states do it?
There's no gerrymandering necessary. There's
If he separated into two courts, ninth and the separated split the states?
no, the president can't split the circuits. That would take an act of Congress.
Okay. But if that were to occur, would he assign some of the judges that are too liberal there and the more conservative ones here, then fill the seats here? If he get it split, can he then gender?
I would assume that what would happen, and don't take this to the bank, that if the Ninth Circuit, one of the reasons to split the Ninth Circuit up is because there are just too many cases here. There's 26 active seats in the Ninth Circuit, and there's a bunch of senior judges who work for free. If the Ninth Circuit were to get split up into, say, California, Oregon, and Hawaii make up, and the Marianas make up or stay the Ninth Circuit, and we create a 13th Circuit out of Washington, Alaska, Idaho, Montana, Nevada, and Arizona, then I would assume that would be a brand new circuit. There would be, that Trump would get to fill every seat. Now, there could be an argument that he would fill only the circuit court seats, and that the district court judges who are already serving as district court judges in those states would keep their jobs. But circuit judges are assigned to a circuit, they're not assigned to a specific state, even though a lot of circuit judges keep their offices in the states where they originally came from. So, complex question. I probably gave you a completely unsatisfactory answer. Yes, sir.
Seeing as we're talking about federal judicial appointments, what are your thoughts about becoming a judge?
I wouldn't take the job on a bet. I wouldn't pass the hearings, mostly because I would be too tempted I would be even more tempted to use colorful language in front of the Senate than I would in front of a court. Yes. I'm not good judge material. I have too strong an opinion on most things. I would not be, I'd have to recuse myself from too many cases.
Would you care to offer an opinion about Article 5 Convention of States?
Yeah, it's a good idea. We should do it. And we should do it now, while nominal conservatives still hold the majority of state houses and governorships. Yeah, good idea.
What was the question?
The question was whether or not we should attempt an Article 5 Convention of States to amend the Constitution. There are arguments pro and con to this. The pro argument is we've got nothing to lose because we're sliding off the cliff anyway. The con argument is that we get into a state convention, it'll be a runaway convention, and all of a sudden we'll have some, mongrel constitution that guarantees the right to, ice cream sundaes every day. I don't think that there's that big a danger of that happening, because remember, once the convention meets and proposes amendments to the Constitution, that still has to be ratified by three quarters of the states. So the idea that, of course, California and New York and Illinois and Massachusetts and Maryland are all going to be, oh my God, don't tamper with the Constitution. You haven't fucking read the Constitution, okay? But they're going to be for not tampering with the status quo because they're winning under the status quo. Okay, whereas the more limited government states, most of the red states in the rest of the country would probably benefit from getting Washington off their back. Yes, sir, all the way in the back. Welcome to you, Matt.
First of all, that Oklahoma case regarding standard ground, that was a complete invention by the wire services and the national media, because I've read the stories within Oklahoma itself, and there's absolutely no reference to standard ground either by local law enforcement or by local media. But I have a question about, is there any public right to know regarding active criminal cases locally when they charge an individual, so that the public can track selective enforcement and selective prosecution about things? The media always seem to get, and always seem to print at least full name, city of residence, and age. So they're getting that from somewhere. What about other things regarding, my specific concerns are things like, were they using high-capacity magazines and not being charged accordingly?
Yeah, criminal cases are public records. Okay, unless it's a juvenile or unless it's a sex crime or something like that, you can go down to the Santa Clara County Courthouse and put in a request to take a look at a criminal file anytime you want to. You can't remove anything from it. Sometimes the police records are sealed on that, but they're all public records. The problem is that they're public records that are stored, on cellulose, and so we don't have a way to access a database and just, type in a search for, give me all murders committed with, semi-automatic, handguns or something. There's just no way to do that kind of research. The government does keep some pretty primitive statistics on types of firearms used. The FBI does, and I think the California Department of Justice does, but I don't know that they actually relate them back to particular cases that you could track the history of a case. I don't know if that answers your question or not.
Are those records open while the case is in progress or only after it's adjudicated?
It's a public record. That's one of the foundations of our criminal justice system, is that unless there's a reason to close the courtroom for privacy, like a sex crime or a juvenile involved, you can go down to tomorrow and sit in criminal court and watch everything that happens. It's open to the public. It has to be, okay? We don't have star chambers in this country yet, okay? Yes, sir.
Are there any, or do you foresee any legal challenges to the state of California and the DOJ handgun roster?
That was the Pena case. It's been argued and submitted. Just have to wait and see what happens.
What is going on with that? What is the Pena case about?
The Pena case was a challenge to the roster. When we started the case, I think there were close to 2,000 guns on the roster. We're down to 700 guns now. The government's theory of the case is that that the roster is valid if there's one gun on the list, because Heller says that you have the right to have a handgun in your home for self-defense, and as long as there's one gun available to the public, there's no violation of the Second Amendment. That's the government's case. Our case is a little bit more, shall we say, free market. It says no, the decision on whether or not to buy a gun, or what model of gun, or what color of gun, or whether it's a left-handed or right-handed gun, should be left to the market, okay? Because we have this little thing called liberty. We're supposed to be able to be free to act as long as there's no violation of somebody else's rights. Now, mind you, the roster isn't, they call it an unsafe handgun roster. I'd love to be the plaintiff's lawyer who went after a police department that was using a gun that fell off the roster, and, oh, you killed my client with an unsafe handgun. Okay. It's not really an unsafe handgun list. These guns are not dangerous. It's just that in many cases, the manufacturer hasn't submitted them for review, or the manufacturer said, wait a minute, you mean I have to submit the blue one and the green one? Okay, they're the same gun. State of California says you got to submit them both. There is some statutory language that says if it's just cosmetic that it can be approved, but the hoops the industry has to go through is horrendous. Anyway, just stay tuned for the Pena case and see what happens. It's another case that's set up for Supreme Court review if we lose. Yes, sir.
Are there exceptions? So on January 2nd of 2018, police won't be able to buy guns either?
You can buy off roster right now.
Yeah, the roster doesn't apply to
It's an
police.
exception for law enforcement.
Yeah.
Wonderful.
Okay, I see 2 more questions. Boss, can I take 2 more? I'm going to take 2 more questions. Seeing no third hand, I am limiting it to these 2 gentlemen. Go.
Can Peruta is taken by the Supreme Court. Is it possible that Chevron versus Natural Resources Defense Council can be detrimental to Peruta in the Supreme Court?
I don't know the answer to that because
Chevron deference.
Oh no, Chevron deference has nothing to do with Peruta. Not even going to be an issue.
I feel better. Thank you.
Okay. Yes, sir.
In those cases that you mentioned where the Supreme Court had denied cert, there were
Dissents?
There were dissents, thank you. Once Gorsuch or whoever is approved and the Supreme Court's fully populated, can they choose to revisit those, or are those denial of certs like permanent prejudicial?
Well, what happens is that once the petition for certiorari is denied, then the case is pretty much dead, and then it enters into a legal phase that we call res judicata, another Latin term that just means the case is over. However, don't despair. The Fourth Circuit, another rogue circuit in my opinion, in the Colby case out of Maryland, also kind of came down on the same side as the Friedman case out of the Seventh Circuit, saying nobody has a right to weapons of war, notwithstanding the fact that the liberals on the court were just, in Heller, were making the decision, oh, no, you have to be a member of the militia in order to have the right to keep and bear arms, which would kind of imply that, well, maybe militia weapons are covered. Anyway, Colby is getting ready to be briefed to the U.S. Supreme Court, so although Friedman probably won't get resurrected, can't be resurrected, Colby will be the stand-in for that. Peruta is going to be the Kerry case, and hopefully either Tixeria or Mance will be the firearms commerce case. And then it would be my humble opinion that we should stop litigating the Second Amendment for a while and expand on those wins and stay out of court for a while. But the primary things we need to have protected now is what kind of weapons can we have, whether or not we're entitled to engage in commerce in these, nobody's saying that there shouldn't be background checks or waiting periods for first-time gun buyers. What we're saying is that the right to keep and bear arms includes the right to buy guns, to train with them, to learn how to use them, you know, that sort of thing. So once we establish the core right, the right to keep and bear arms, we need to expand it to commerce. We need to expand it to what kind of guns. Then we need to also address the issue of, well, what do you have to do to be disqualified from having it? And right now, the line seems to be, you know, somebody who's actively engaged in domestic violence and, you know, convicted felons, whether that should be trimmed back to only violent felons. In other words, should Martha Stewart be able to have a gun because she just committed stock fraud, or she lied to the police department or something? So once those are established, we should sort of sit on our wins for a while, because one thing that, while all this is going on, while all these court back and forths, and remember, addressing Second Amendment rights through the courts is always a binary choice. You either win or lose in court. You know, never ever neglect to give credit where credit is due. The NRA is still legislatively winning a lot of our rights, not in California, unfortunately, because the climate's just too hostile here. But just in the past, since January, we've got 2 more states that are constitutional carry, I think. There's North Dakota went constitutional carry. Kansas is getting ready to go constitutional carry. New Hampshire just went constitutional carry. So the NRA is still doing the heavy lifting legislatively to make, and once we secure a right like that, constitutional carry, in a majority of the states, it's going to be pretty hard for California to be the outlier and say, oh, no, you know, the people who live in our state are complete assholes and they shouldn't have guns in public. Well, wait a minute. They can walk around with a gun without a license in 40 other states. What are you talking about, California? I want to be there when the U.S. Supreme Court asks the California Attorney General exactly that question. What is it about the people of the state of California that they are particularly dangerous, but the people of, say, North Dakota aren't?
They're Democrats.
What's that?
Democrats.
Oh, they're Democrats. Haha, you're funny. My guess is not too many Democrats are applying for licenses anyway. Although, interesting point, and I'll close on this note. One of the fastest growing segments of the gun buying public are all the people who voted for Hillary last November. Because for some reason they've become afraid of us, and I have no idea why.
Ladies and gentlemen,